record in the matter 22 CF 25424 CF 101, State of Wisconsin versus Stephanie Current. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Stephanie Current appearing in person in custody with counsel Michelle Erdman. We're set here today in this matter for the sentencing portion of this case. Ms. Current pled guilty to operating with restricted controlled substance.
Strap in, because this case isn't just another courtroom snoozer. It's a legal roller coaster with bail jumps, substance abuse, and even a toddler in the mix. Let's break down why the sentencing hearing matters and why the judge is already side-eyeing that case file.
6 with minor passenger under the age of 16, as well as 2 felony bail jumps on September 10th, 2024. The court ordered a pre-sentence investigation report. The court has reviewed that report as well as the recommendations in the report. For the record, the court does note that at first the court was a bit confused because it noted Ms. Current's name as Stephanie Bogat in the report. And so I am not quite certain if her legal name is Current. Note any other, I believe, corrections or modifications of material nature that jumped out to me or I would be aware of. Mr. Schmidt, did you receive a copy of that pre-sentence investigation report?
I did. I have one correction. They list the offense as the OWI 5 or 6 with minor in vehicle, which it got amended as part of the plea agreement. And they also list the minimum penalty for that is a period of confinement on the bifurcated sentence of not less than 6 years, which appears to be just plain mistake, because that's not what that wouldn't be consistent with what they recommended. So I think they maybe just forgot to edit that.
Not less than 6 years. Yes, I believe that is also noted. Ms. Erdman, did you receive a copy of the pre-sentence investigation report?
We did, Your Honor.
And did you review that with Ms. Current?
I did.
And did you note any other corrections or modifications of the material nature to state and note for the record?
Your Honor, the name correction, they had used, there was a prior PSI completed by Ms. Current, and I'm not clear when that was, but that's her former name. Today it is Current. The next thing that we noted was indeed consistent with the state's recollection. So just so that we're all aligned, it's a OWI 5 or 6 minimum penalty.
Okay, pause. 5th or 6th time. With a kid in the back seat? This isn't just bad luck. This is a pattern. Quick question for you all. At what point should repeat offenders lose driving privileges permanently? Drop your take in the comments.
A year and a half, right, without the enhancer. And then she's obviously got the 2 felony bail jumps, and those I believe each have a maximum of 3 and 3. I think how that breaks down.
All right.
Just so that we, and then in terms of
the error as to the 22 CF 252 count 2 for the maximum penalty.
I don't even know how they reached 6 years, because that's not even the minimum of what she was charged with. That's super weird.
I'm not clear on
I'm not
all
clear
of that,
as to that either.
But at any rate, I did go through this with Ms. Current, and Your Honor, on page 3 at the bottom under defendant's version, the very last line, it says that she's got a motorcycle group. She just wants Your Honor to be aware that this is not a gang or it's just people that she knows that ride motorcycles. Top of page 4, there was a statement that the daughter refused to take the defendant to the hospital because she thought the defendant was consuming alcohol and using substances, and then the word again appears, and she said that should be stricken.
Oh, I know where they got it. They got that from the original criminal complaint where it originally charged the 7th, 8th, or 9th with a minor in the vehicle. So sorry, go ahead.
That's fine. So the next line in that, at the top of page 4 again, still in that top box, it says the defendant left and drove to Tim's house. She was stopped by law enforcement in Siren, who noted she had swerved, and then it says off the road. She said that's not accurate. They noted she crossed over the center line. And then she made a commentary here that at the time that she was driving during that incident, she did not know that her driver's license was canceled. And I believe she had gotten some assurance from oh, I'm sorry, that's something else. So that was her comment there. On the next page, page 5, does it say Tim? Car going to the junkyard? What was this about the junkyard?
He took out the device because
Oh, okay.
I
I'm
was
sorry.
responsible for
So
it. and
for
I
the
wasn't.
That's not on the record.
For the OWI, on the top of page 5, Judge, there's a OAR without an interlock device that she pled guilty to in 2024. I believe was a part of this, actually. And her commentary was that Tim, who's in the courtroom, had removed the interlock device because the car was being towed to the junkyard following this incident. The car was totaled out, so the IID device was removed from the vehicle so that the charges would continue to accrue. The next thing that she noted was on page page 16, Judge, under the heading of sexual behavior, there's a statement from the PSI that was previously completed, some reports of assaults, and she denies those today. So that whole section should be stricken. The line on page 17, speaking to her cocaine usage at the age of 20, the statement was made, she estimates using less than a gram when she would use and would snort it. And she said that she doesn't understand what a gram is. She isn't able to differentiate that. All she knows is that it was a line and she would snort it. So that's the correction. And then the agent's impressions on page 23, the third paragraph, these are obviously impressions by the agent. She affirmatively denies that she has anger issues or poor coping skills, and in fact, she would assert that she has exceptional coping skills. And then the next paragraph, there was a statement about the methamphetamine and benzodiazepine, and she admitted to law enforcement the day of the accident she had snorted a white powdery substance. And the report says a day prior to not knowing what it was. She says that was 2 days prior to the incident. And then again, that bottom paragraph on page 23, where she's characterized as having impulsive behavior and poor decision-making skills, she indicates to the court that she does not believe that that's an accurate statement. And that's all the changes that we have, Your Honor.
All right. Thank you. All right, Mr. Schmidt, we will proceed with you with argument and sentencing recommendation.
Thank you. Judge, with this case, we have a 60 felony bail jumps. In the instant offense, Stephanie Current used Xanax and snorted a white powder given to her by a biker friend before getting it.
Here's some legal housekeeping. They're dissecting the PSI or pre-sentence investigation. Think of it like a life resume of the defendant that judges use for sentencing. Any mistake in that report, even something small, can tip the scales. That's why the lawyers are nitpicking every comma.
and got into a car crash. The blood confirmed the presence of Xanax at 170 nanograms per liter and methamphetamine at 120 nanograms per liter and amphetamine at less than 40 nanograms per liter. The therapeutic range for methamphetamine, according to clinical lab reference manual, is 20 to 30 nanograms per milliliter, making Stephanie's 3 to 4 times the therapeutic level. Normal dose for aprazolam is supposed to have a 5 to 25 nanogram per milliliter for therapeutic base. That's what the Xanax is, with high-dose aprazolam therapy having a resulting range of 25 to 55, meaning the blood level of the Xanax was also quite high. Current contends that she didn't cause the crash, and so she can't be blamed. That's the impression I've gotten from the numerous hearings we've had, going all the way back to when Dan Chapman was the attorney, from the comments she's made in the PSI. My take on it is it appears that her main problem with this conviction isn't a disagreement about whether she used the drugs, whether she was driving, anything like that. She believes she was rear-ended due to no fault of her own, that the person behind her was driving poorly. Should be noted the person behind her indicated she was driving erratically to law enforcement, stopping and starting suddenly without reason. Regardless, getting drawn into the debate of who was at fault is irrelevant to what this offense actually is. That's not an element.
And here's a bombshell. Blood work doesn't lie. Xanax through the roof, meth in the mix, total in the backseat. This isn't a bad decision. It's a walking disaster scene. Imagine being that juror hearing these numbers. Instant goosebumps.
The point is, her disagreement is that she didn't feel intoxicated. She didn't feel impaired. That's the thing we've been seeing over and over and over in the PSI, in her words to law enforcement at the scene, in court. Reading from her PSI, I get the impression she didn't think a single bit about the danger she was putting her granddaughter in, herself in, the public in, because she didn't think she was impaired. She mixed prescription medication Xanax with unknown white powdery substance from a biker friend, which turned out to be methamphetamine, and she didn't think she was impaired. That's a big problem because that shows a lack of insight. It shows extremely poor coping, especially with the history of substance abuse. That she doesn't see how she's putting all these people in danger. That she doesn't see how she continues to kill herself by doing things like that. How you destroy your own kidneys and liver when you're taking prescription medications, and then biker friend, unknown powdery substance. Why not? When I'm talking about substance abuse, what's important to look at with Ms. Current, I'm not just talking about alcohol, which has been a problem in the past, or the methamphetamine. I'm talking about the prescription medications. Just because you're getting something legally from a doctor doesn't mean you can't kill yourself or someone else with it if you don't use it responsibly. Judge, I'm actually going to be recommending a higher sentence than what DOC recommends. I'm recommending 4 years initial confinement, 4 years extended supervision on the OWI, and then 3 in, 3 out on the bail jumps concurrent to that. DOC recommends effectively double the mandatory minimum what Current was convicted of. The 1.5 is what it is the minimum. I think DOC looked at this and appeared to recommend the mandatory minimum of what she was charged with prior to the offense, prior to the amendment of the information, because there was a child there and because of the past history of non-adjustment and the fact that, she's had a lot of past OWIs and a lot of failed treatment attempts. I have a number of problems with taking that sort of a simple analysis that I think DOC did. First, is really predicated upon public protection and incapacitation. When we read the PSI, we see a trend of Current moving away from alcohol and into these prescription medication and drug abuse. The OWI she beat at trial in Washburn County in 2016 involved she failed fields, police drew her blood showed morphine, Prozac, and Valium. She wasn't convicted of OWI. I'm not saying the court should consider it as a conviction for OWI, but it's another situation where a lot of prescriptions in her system and she wasn't able to do fields. Her Burnett County 2020 DC, drinking margaritas after Xanax, Prozac, and Abilify, combining alcohol with prescription medications. That trend of obviously not using prescription medications as she's supposed to was there, of endangering people under the influence of them. that, when you see happening now at 65 with the past history of drug abuse, the past history of alcohol.
So here's a strategy. The prosecutor is stacking history on top of history, showing Stephanie as someone who's had chances, treatments, even courtroom breaks, and still spirals back. In legal terms, this is a pattern argument. In human terms, it's a court saying, we've been here before and nothing stuck.
The PSI details her treatment history, and she fits all three categories. She's completed treatments, she's failed treatments, she's refused treatments. Regardless what you conclude from that, she's done probably near everything we can imagine. The PSI compass weirdly says she's low risk to reoffend, which I don't understand how you can reach that conclusion when the conviction is OWI 6, because you already have the trend of at least 5 beforehand. Her last 2 convictions both being OWI 5 or 6 previously. Especially in a situation where the defendant appears to mitigate or deny responsibility because they didn't feel impaired. DOC alluded to this in its conclusion, despite the compass analysis, because they noted polysubstance abuse. They noted that there was mitigation. They noted lack of insight means doesn't comprehend the danger she's putting people in. That's what they're also referring to with the lack of coping skills. You can't say someone has good coping skills when they're just biker person presenting you a line of white powder. Do it, sure, don't even ask what it is. That's not good coping skills. That's atrocious coping skills. I think that Stephanie Current has absolutely no insight into how her substance abuse problem is, how it affects her, and how it affects other people. I don't see how you could come to a different conclusion based upon the facts of this case and her past history. Well, in bond even, she continued to drive, and there was poor jumping for that. It wasn't even just stopped for an equipment violation. To be blunt, what I'm getting is whatever rehabilitative potential I think she has is grossly undermined by her failure to rehabilitate over the decades that she's had this issue. I'm sure she and her attorney are chomping at the bit to say how this time's different, just as I'm sure the past OWI she did in front of all those judges. But on that topic, I want to talk about the past OWIs. I have a problem with the 3 and 3 out recommendation of DOC because it's just not proportional when you look at the past sentences. Her last 2 OWIs were both OWI 5 or 6s in Barron. One was Barron 11 CF 413. That one, they somehow did 6 months prison, 6 months extended supervision. She filed a motion at some point to be sentenced to probation with 6 months conditional jail at Huber. It's been over a decade. She still hasn't paid the fine on that, so that sentence isn't even fulfilled. The other OWI 5 or 6, 2008 CF 298, she got 3 years probation with 1 year conditional jail on that. She wound up getting revoked because she committed an OWI while on probation. She got sentenced to 2.5 and 3 out, has not paid the fine on that either. I don't believe going only 6 months higher than the last OWI is proportional when we have an offense with aggravating factors present. The aggravating factors being there was an accident. There was a child in the vehicle who was 2 years old. There is denial of responsibility or mitigation. The complaint that I didn't think I felt impaired. There's an utter lack of insight here that says to me this is highly likely to happen again, and that there is a need for both specific and general deterrence here. I think that Stephanie Current has been captured by a type of criminal thinking that is marked by that lack of insight. I think that when she's on her own, thinking to herself, the rumination she has about this case is, if that guy didn't rear end me, none of this would have happened. I think that's what her main thought process is on this. And that's the thought process of someone not inclined to change. And when we see that thought process in a 65-year-old woman with decades of this same sort of history, the same people in danger by getting behind the wheel with substances in you, by being impaired, that's a huge problem. She's not a young 20-some-year-old with a developing brain where she might grow out of it or something like that. And that's why I'm asking for 4 and 4 out, because I think that's my best shot at trying to protect the community. The best shot I have of impressing of her the significance of her actions, because I don't think she's going to reach that conclusion on her own. And what's also impressing with the public, the general deterrence of this, that, you know, we don't ratchet penalties down as you get more and more OWIs and commit them in a more aggravated way. We ratchet them up. She's 65 years old, Judge, and she's snorting drugs with biker friends without asking what they are. And that's what she's admitting to. It's one thing to do that and stay home and not make it anyone else's problem. It's another when you get on the highway with a 2-year-old in the back of your vehicle. So for those reasons, I think it needs to be higher than 3 and 3.
So how are you asking me to, what are you asking per count?
4 and 4 out on the OWI, 3 and 3 out on the bail jumps, those all concurrent to the OWI.
So 4 in, 4 out with 22 CF 252, count 2, 3 and 3 out for each of the felony bails, all concurrent to each other.
Yes, and even that recommendation isn't a max recommendation. Thank you.
All right, thank you. Ms. Erdman, argument and sentencing recommendation.
Your Honor, our request is the mandatory minimum of 18 months on the OWI, and then for the felony bail jumps, we would ask for 1 year concurrent on each. This current, when I met her, had a pretty strong belief, and a lot of it is true, what the district attorney has stated. So from her perspective, the gentleman that hit her car was someone who was operating without a driver's license and had an accident just a few weeks prior, had totaled out his own car, was actually driving someone else's car. So from her standpoint, this did, precipitate from someone else's behaviors. And I think the thing that we struggled with in coming to some type of a resolution was that there's a strict liability or a mandatory, if you've got something in your system, if there's something in your bloodstream, then you can be found to be guilty regardless of when it got there. And I think that was probably the biggest thing that we needed to overcome. And once I was able to explain that to her following, I think, the suppression hearing, it was then that she conceded that there was a basis to enter a plea and did so. So prior to that, I think there was kind of